So Judge Vilardo, 3 years ago, you're watching TV. Is your heart pounding?
Oh my gosh, pounding isn't the word for it. I was white-knuckled. I was sick to my stomach. I was, worried about. I had been told we really don't have to worry about it at this stage. It's in the bag, but I was still a nervous wreck. Yeah, absolutely.
What is it that Terry just set the stage. You were, private practice, very successful private practice, Connors and Vilardo. What is it in your heart of hearts that I want to be a judge?
I clerked for a judge by the name of Irving Goldberg in Dallas, Texas in 1980-81, a federal judge on the Fifth Circuit. And when I saw the kinds of cases that the federal courts handle, and when I saw how seriously he took his job, and when I saw the good that a good judge could do, I wanted to be a judge back then. And in fact, as I told some folks at lunch, when Terry and I started the firm together, when Terry came in my office one day and said, "Would you like to start Connors and Vilardo?" I thought he was joking, actually. And when he convinced me he was serious, I said yes. And he said, I want to know that you're going to stick with us, that you're not going to leave me a couple years. And I said, "Terry, the only thing I'll leave you for is an Article III judgeship," and we both know that's never going to happen. So it's been something that I wanted to do my entire career. There was not an opening in Buffalo for 25 years. So it was starting to look like it was never going to happen, especially when my age approached 60. And then, as Terry said, there was a confluence of very lucky stars that happened, and I got to be able to do it. So.
Talk about the Honorable Irving Goldberg. You actually wrote an article talking about the Honorable Irving L Goldberg, a place in history. What place in history did he have?
No, an amazing place in history. So Judge Goldberg, when he was lawyer Goldberg, started a law firm, was 13 lawyers when he left. It's now called Aiken Gump. It's a multinational, huge law firm. That was the law firm he started. He left Aiken Gump when his very good friend and client, Lyndon Johnson, asked him to join the judiciary. When John Kennedy was shot in Dallas, Texas, which is where Judge Goldberg was practicing at the time, the very first phone call that Lyndon Johnson made was to Irving Goldberg.
Okay.
And asked him, and it's in the article, and asked him, "What do I have to do now? What do I do? Am I president now? Do I have to get sworn in?" And Judge Goldberg, who had done some quick research anticipating the call, told him that he was president, but that he should be sworn in. Judge Goldberg recommended that Sarah Hughes, the woman in the great photograph on the airplane, be the person to swear him in. So Judge Goldberg was a place in history there. He was also a place in history. He was on the panel, the 3-judge panel that decided Roe versus Wade. And so place in history there. There are too many. There are too many of those stories to be able to tell. Let me just say this, though. One of the great blessings of my life was working for Judge Goldberg. He's one of the greatest people that I've ever had a chance to meet. He was a great judge, but more important to him and more important to me, he was a good man. And it taught me an awful lot about everything. It was truly a blessing in my life.
So, Judge Wolford, I just want to know, is Notre Dame going to make the playoffs?
Oh, absolutely. They're going to win everything.
Yeah. Guess who went to law school at Notre Dame? Was law in your career? I met your dad previously. Was that part of your world?
Well, yes. My father is an attorney. I practiced with him for over 20 years before I went on the bench, and my uncle was a criminal defense attorney. I have a number of cousins who are attorneys. My brother's an attorney. Law permeates throughout my family. So I remember growing up, and my dad would come home from work, and we always had dinner together, my 2 younger brothers and I and my mom. And my dad would tell stories about his cases, and he just made it sound so fascinating and so interesting. And I actually wanted to be a journalist. I loved writing, and that was initially what I was perhaps going to go into. And I will say my dad definitely had some influence in convincing. I wanted to work for a newspaper, which I think in hindsight it probably was a better career choice to go into law. since a lot of newspapers are struggling these days. But it certainly was in the blood, so to speak.
And as a result, did you find, why Notre Dame?
Well, they were the national champions when I was a senior in college, so it was one of the law schools that I applied to. They really were the national champions when I was a senior in college, and I think they were more on my radar than they might otherwise have been. I was born and raised Catholic, but I had never gone to Catholic school. Both my parents had gone to Catholic school. My mom taught at the local girls' high school when I was growing up. I went to public schools throughout my high school years, went to Colgate undergrad, and it was the first time I ever prayed at the beginning of class when I went to Notre Dame Law School. I learned the Hail Mary, actually, in my contracts class.
Was that right?
Yes.
And similarly, when the touchdown, Mary, was it?
Yes,
Yeah.
exactly.
If you haven't been there, it's a hoot. Judge Vilardo, what was your concentration in practice before you, found yourself sort of on the judiciary? What was that area that you felt the most comfortable doing?
So at Damon and Maury, when I started, Terry Connors was the partner I worked for at Damon and Maury. We did a fair amount of medical malpractice defense work, and we did criminal work as well, but the medical malpractice defense really interested me. And as my career as a lawyer evolved, I represented professionals. And by the end of my practice, I probably spent about 60% of my time representing lawyers, which is fulfilling. It's also very nerve-wracking because when you've got someone who knows the profession and knows litigation as your client, you better do a good job. So it was a little scary from time to time, but I did a lot of that. I also did some arbitration and mediation toward the end as well. But the practice that I had, as Terry said, our practice at the firm was as broad-based, still is, as broad-based a litigation practice as you could possibly have. We did everything except matrimonials. We made a pact with each other when we started. We weren't going to do matrimonials, but we would do everything else. And we did everything else. We did will contests. We did real estate litigation. We did plaintiff's work. We did defense work. We did criminal. We did civil. We did state and federal. We did appeals and trials. We did a little bit of everything. But my personal practice was certainly a majority and maybe a great majority representing professionals.
Do you have a preference, state versus federal?
I mean, I always had a preference for federal court. That was as I said before, I told Terry I'd leave him for an Article III judgeship, not a state judgeship. So I always loved federal court. I think I always liked, when and we'll probably talk about this a little later when we talk about best practices, but I always liked a more formal argument. There are some judges in state court who would have us come up to the bench and argue very informally and just kind of conversational. And while that's easy, I never liked it that much. I always felt that I was more effective when I argued from a podium in a more formal way. And one of the things that Terry taught me when we practiced together was to gain control of the courtroom as soon as you can. And I don't think you do that in an informal conference at the bench. I think you do it from a podium where you can, show that you know your case, that you know the law, and that you're in control. And so I do like that, and I did like federal court because you never argued at the bench in federal court. It was always from the podium.
Was there a judge or two that during that time period that may now be retired, so you're not a colleague on the federal bench, who you kind of took notes about, kind of respected his judicial decorum?
Well, there are lots of judges who have had a great impact on me over the years. Judge Scratney and Judge Arcara in federal court, who I practiced in front of an awful lot. One of the judges who had a terrific impact on me for a reason that I was not particularly pleased with at the time was Judge Fred Marshall. I was arguing a case in front of Judge Fred Marshall as a young lawyer, and I was very passionate about what I was arguing, and I didn't give a darn what he was saying. I was going to tell him what was on my mind. And finally, he got very frustrated with me, so he shut up and let me finish my argument. And then when I was done, he says, "You mind if I say a few things now and ask a few questions?" And of course, I was horrified. But from that moment on, I never, ever, ever opened my mouth when a judge was, I realized at that point how stupid it is to talk when you should be listening, because what's on the judge's mind is a lot more important than what you want to say. So it made me take a step back and realize that. And I really think from that moment on, and probably in my second year of practicing, I never talked when a judge was asking a question. So Judge Marshall had a kind of a profound impact on me, but there were lots of judges. And another one of the blessings I had was when Terry and I were at Damon and Moore together before we left and started Connors and Wetto, Chief Judge Desmond, Charles Desmond, who became a very, very close friend of Terry. In fact, Terry's son's middle name is Desmond, Matthew Desmond Connors, after Judge Desmond. But he was a mentor to me and taught me a lot about appellate practice. And one of my favorite memories of Judge Desmond was whenever I would be going off to argue an appeal, he would send me out the door with, "Give him a good show." And those were his words of encouragement to me as I walked out the door.
Judge Wolford, you were with a law firm with your dad, right?
Right.
And what part of the practice did you have? Criminal litigation, civil litigation? What was it known for?
So the firm actually similar to Larry and Terry's practices in some ways, I suppose, is a litigation firm, and all we handled is litigation except matrimonial cases. The firm handled both criminal and civil. I was focused almost exclusively on civil work. I had really no criminal experience until I became a federal judge. I handled a lot of commercial litigation, some very significant, complex contractual disputes, a lot of employment work, and some personal injury work. But I would say towards the end of my practice, before I went on the bench, I was primarily handling what I would characterize as complex commercial litigation. So what does that really mean? Because when I was in law school, I remember my contracts teacher saying to me, asking her, "Well, do I have to take corporate business law?" And I remember her saying, "Well, do you want to practice commercial litigation?" I thought, God, no. Why would I ever want to do that? That sounds so boring. And one of the types of cases I handled was a dispute about commercial satellites that originated from a government classified contract. They became commercialized, create your Google Maps, your all the mapping that you see on the internet. We represented ITT, which was suing the manufacturer of a part that went into these satellites that controlled the camera that took the pictures. And unfortunately, there was an electrical short in what was called the clock driver that controlled the camera. And it's a little difficult to fix that once these satellites are up in space. And unfortunately, they did not realize that there was this issue until the satellite, or at least one of them, was launched. And so a lot of my time shortly before I left was spent litigating that case, taking a lot of depositions in other parts of the country where these satellites were manufactured. And what I loved actually about cases like that is you end up, I had no engineering background. I didn't know really anything about electrical engineering. And you become immersed in the facts of your case, and you end up learning so much about a totally different area that you wouldn't normally have gotten involved in. And that's what I really enjoyed about litigation. You end up learning about so many different areas and so many different scientific backgrounds and so forth that you wouldn't normally have an opportunity to get involved in.
Yeah, that's really true of the medical cases. So I have a brother who's a physician, and he has told me that I would be a really good quack because I have enough medical knowledge and know the terminology well enough that I can sound like a doctor. Now, he says, when you push, you realize it's all superficial. He said, but boy, he says, you could go into a medical practice and sound like a doctor any day of the week, and it's because of that. It's because,
Right, because you have to learn how to be able to, you have to learn enough to be able to question the people that know a lot more than you do on these particular subjects.
So, both of you had an experience, I'm sure, at some point, that aha moment where all of a sudden somebody may have reached out to you and suggested that perhaps you might be qualified or worthy to be a judge and to be nominated. And I'm curious at that, where that moment, what was that moment where you went from practicing law till somebody said, gee, this could be real? Judge Vilardo, what was that magic moment? Was there a call? Was there somebody who said, hey, guess what?
So I was on an airplane, not on an airplane, but at an airport on the way to Puerto Rico when I got a text message, I think, from Terry that said, come back, Judge Scretany is taking senior status. And that's when I realized that, there was a chance that something was going to happen. But that was sort of the moment that I realized that there was a shot at, as I said to my wife as we went through the process, okay, the odds just went from, 1,000,000 to 1 to 10,000 to 1, and then the odds went from 10,000 to 1 to 200 to 1, and then 50 to 1, and then 3 to 1, and then eventually it happens. But that was the moment when the light bulb went off in my head that maybe this could happen.
What's the next steps?
The next step after that happened? Calling in every favor that I ever did for anybody. Finding out who had, I knew Senator Schumer was going to make the recommendation, so finding out who had Senator Schumer's ear in Western New York, calling one of my best friends from law school, Senator Mark Warner from Virginia, who knew Senator Schumer very well and was, according to Senator Schumer, relentless in his pursuit of Senator Schumer's recommendation of me. And then, just talking to people, talking to Terry, walking into Terry's office one day and saying, I think I've got a shot at this, but I can't do it without your help, and I need you to help me, and things like that. So a lot of people came together to help. It doesn't just happen. Terry said that I was qualified for this. There are thousands and thousands of lawyers who are qualified to be judges. But to become a federal judge, the stars really have to align. You've got to be very lucky. It's more luck than it is qualifications. And I happen to be very lucky. Things just worked out the way I wanted them to. And the rest is history, as Terry said.
Well, did Senator Schumer call you at some point and say, I'm going to submit your name?
He did, yeah. So I had interviewed with his committee in New York City. And then a week later, I got a call from him saying, I'd like to interview you tomorrow. I actually had an argument in court the next day, but went to my partners and said, somebody's got to cover this for me. I'm flying to New York. And so I went to meet with him. And then probably about a month after that, I got a call from the senator himself to tell me he was sending my name to the White House.
Can you divulge a little bit about what the conversation was like with Schumer?
That conversation with him? It was very gracious, to be honest with you. He said, you recognize that this is a merits-based appointment. As Terry said, I was never involved in politics at all. I was politically invisible. Mm-hmm. And Senator Schumer said basically that. You're politically invisible. You weren't on the map. He said, but when people put your resume in front of me, I was impressed with it, and I want you to know this is a merits-based appointment. This has nothing to do with politics. So it was very gracious, very, very nice conversation with him. I was moved and humbled and, felt very good about it.
Judge Wolford, what's your travel here?
Mine's a little different, in part because I really never gave any thought to being a judge. I love practicing law. I would be perfectly happy if I was still practicing law. And I don't mean that in the sense that this is a wonderful job. I am so fortunate to be in the position I am, but I love being a litigator, and I never really had any aspirations to be a judge. When a seat became available in Rochester, though, there had never been a woman who has been appointed as a district judge in the Western District of New York. And so Senator Schumer's office was making a concerted effort to reach out to female litigators to encourage them to apply. So I got a call from Senator Schumer's office asking if I was interested in applying for the position. And my initial reaction was, I've never really thought of doing that before, and I'm perfectly happy practicing at the Wolford Law Firm. And I went and talked to my father about it, whose attitude was, you'd have to be nuts not to, of course you have to apply for that. That's a once-in-a-lifetime opportunity, and you'd regret it if you didn't put your application in. So I have to say, I went through this whole process, though, kind of the attitude, well, I'll put my application in. I'll see what happens with it, but it's not something that I have sought out, and so if it doesn't work out, that's fine. So the first step in the process that I went through was I went and interviewed with a committee. I think you probably interviewed with the committee too. Senator Schumer has a committee of attorneys down in New York City, and you go and interview before that entire committee. Now, there were a number of other very well-qualified attorneys in Rochester, sitting judges, who were also applying for the position at the time. It's almost like a cattle call. You kind of run into each other in the waiting room before your 20, 30 minutes in the committee. And so I interviewed with the committee, and then after that, I was called back along with two other candidates. All of us were women, to interview with Senator Schumer. Again, though, the two other women who I knew who were being considered were sitting judges, and so I approached it with the belief that, in all likelihood, I was honored. It was very nice to be considered, but I wasn't a sitting judge. I had no judicial experience. And then a couple weeks later, I got a call from Senator Schumer's office indicating that he was going to be recommending me for the position. And then the fun part really starts, where you go through the Senate Judiciary Committee and the vetting with the White House and the FBI background investigation. And it's been announced at that point. So I remember thinking, my gosh, if this does not work out, I mean, my whole career, my life is going to be over, because you're really kind of out there and exposed. But thankfully, it all worked out.
Did you have to go before the Senate Judiciary Committee?
Sure. So ultimately, after Senator Schumer recommended me, a couple months later was nominated by President Obama after the FBI background check and after the White House vetted me. And then I went before the Senate Judiciary Committee.
This was Obama, right?
This was during President Obama's term. Senator Schumer actually, it was while the Senate was Democrat too, and Senator Schumer was the presiding senator at the hearing. And I actually, the day of my Senate Judiciary Committee hearing was also the day that Patty Millett, who was the first of the Dc Circuit nominees to be considered for 3 spots that were open on the Dc Circuit, had her hearing. And there was a lot of coverage of this. Every single senator was on the panel. It was like a Supreme Court hearing, really, because there was a lot of controversy and debate over whether or not all 3 of those seats on the Dc Circuit should be filled. So all the senators that are out there, Senator Cruz, Senator Lee, every single senator is there asking her questions, and then the district court nominees go up after the appellate court nominee is up there and answers the questions. And thankfully, they all cleared out. And so it was Senator Schumer and Senator Grassley were the 2 senators who were there and asked myself and my 2 other panel mates questions. And I can tell you, going through, and I'm sure Judge Vilardo says this, going through an experience like that, you form lifelong bonds with your other panel mates in terms of what nobody else is experiencing. It's surreal, really, to be in front of a Senate Judiciary Committee, them asking you questions. You have no idea what questions they're going to ask you. The Department of Justice prepares you and the White House prepares you, but you really have no idea. You have to submit everything that you've ever written in any kind of publication, anytime you've ever spoken publicly, and it's a nerve-wracking, but also just unbelievable experience, because when I went through it, I thought, well, when am I ever going to have an experience like this again? So
What was the shock question? What was the one you didn't see coming?
honestly, the questions were pretty softball questions. Yeah, I mean, one of the questions, Senator Grassley, one of his questions was, what will you do when a case from the Wolford Law Firm is assigned to you? And I said, thank you very much, Senator Grassley, for that question. I will
Decide it in their favor.
I said, I will recuse myself from any case that comes before me from the one difficult question that I did get, but it was in writing. I was president of the Women's Bar Association in Rochester several years earlier, and we were celebrating Law Day, and Brown versus Board of Education was the case that was being celebrated at Law Day. And I wrote an article in favor of same-sex marriage. The Massachusetts state court had just come out in favor of same-sex marriage, saying it was unconstitutional not to allow same-sex couples to marry. But at the time I wrote the article, it was much more controversial subject than it is now. And I had a phrase in there that I got asked about in my written questions by Senator Grassley. Thankfully, he didn't ask it of me at the hearing, because I'm not sure I would have been able to respond as quickly, but I had a statement in there that when it comes to issues of civil rights, the views of the majority have no usefulness. And his question was, well, is it your view then that the views of the majority that are reflected in legislation should be struck down by the judiciary or something of that nature? And I explained in my written response that what I meant is, when it comes to issues of constitutional rights, the rights of the minorities, in the case of Brown versus Board of Education, trump the views of the majority. But thankfully, I wasn't asked that at the hearing. I may not have been able to come up with as quick a response if I had been.
So what was your hearing like, Judge?
It was nerve-wracking again. There's a theme here, isn't there? It was, so we had three senators actively asking questions. Senator Tillis was the Republican from North Carolina. Now, he was the most junior member of the Judiciary Committee on the Republican side, so we figured we were okay when they sent only the most junior members, so we were happy with that. And then Senator Al Franken, who was very funny, and Senator Klobuchar, both from Minnesota. Senator Klobuchar gave me a hard time about the Buffalo Bills fans throwing ice balls at Chuck Foreman during a football game in Buffalo years back, and I apologized on behalf of the Bills fans, prompting my partner Randy White to say I folded faster than France. But it really was a kind of a feel-good hearing, as Judge Wolford said. There were not any difficult. The toughest question that I was asked by Senator Tillis was whether I'd be fair to both Democrats and I was an Obama appointee too, and whether I'd be fair to both Democrats and Republicans, which is an easy question to answer.
I can handle that.
So it was a pretty now that was true of three of us on the panel. The fourth judge on the panel actually was given a very hard time by Senator Tillis, and he's now a district judge in California. He was confirmed, but he was a magistrate judge at the time, and he had issued a couple decisions that caused some concern for the Republicans. So they asked some hard questions, and he actually had a fair number of votes against him when he was confirmed. And the first question asked was of him. So the other three of us got very scared at that point, but it ended up being a pleasant experience.
So you were appointed in December 17th, 2013. Do you
My
remember?
birthday.
Was it?
Wow.
Yeah, that was my birthday.
Oh, wow. So did you listen to it? Were you glued in?
So I was the first, going back to the DC Circuit nominees. So this was a politically controversial issue at the time. And so in September of 2013, the government shut down. So then everything came to a standstill. And then once it got back up and running, I think a couple weeks later, the senators were debating whether or not these 3 nominees for the DC Circuit Court of Appeals should get a vote. And at that time, in order to get a vote in the Senate, you needed 60 votes, 60 senators. The Democrats didn't have 60. And the Republicans there would not go along with giving these 3 nominees to the DC Circuit vote. And so the Senate went nuclear and changed the voting threshold at the time for every judicial nominee other than the Supreme Court, that you only needed a majority, not 60. The Republicans were very upset about that, and they filibustered and required debate for as long as they could require it. So the Senate pulled an all-nighter, and I was the first district judge who had a vote after the Senate went nuclear. And as we all know from the recent Supreme Court hearing, ultimately, the Senate changed that voting threshold down to a majority for Supreme Court nominees as well. And I think some feel that it has changed the landscape in terms of who is ultimately for either party getting nominated, because of the fact that you do not need now bipartisan support. You can have a vote and come to the floor as long as you have a majority support.
So this is the Wolford Rule.
Well, I don't know that
Nice.
it's a Wolford Rule, but
It
I
all
was,
started
so,
with you, huh?
so it was an all-nighter. I had Senator Schumer, the White House, Senator Schumer's office was emailing me in the middle of the night, saying, I was sleeping, I will say, because at that point, you didn't know when the vote was going to happen, but ultimately, I was told it was going to be at 6 o'clock in the morning. It ultimately ended up being about 8:30 in the morning, and I was at work and was watching it with my colleagues at the firm.
Did you take the day off?
No, I went back to work. I mean, what are you going to do?
So Terry actually put on a party for you. I mean, he actually sprung for bought a big screen TV and all that
Big
stuff.
screen TV in the library at the firm, and my kids were there. At least one of my kids was there, and it was it was pretty. It was a lot of fun. It was a lot of fun. As I say, it was nerve-wracking. I mean, I was told that we were okay, but until it actually happens, you're not sure.
Just a curiosity, you mentioned Rochester, you mentioned Buffalo. I don't think there's never been a female Buffalo district court judge, is there?
No, there was a magistrate judge, Carol Heckman, but no, there's never been a district judge. And in fact, Senator Schumer had recommended, so when Judge Arcara and Judge Scretany both took senior status at the same time, Senator Schumer made 2 recommendations. The first recommendation he made was for a woman, and then I was the second recommendation. But for whatever reason, the White House did not nominate the woman who Senator Schumer recommended. So that second seat is still vacant right now, and John Sinatra has been nominated by President Trump for that seat and is awaiting a vote in the Senate.
Has it gone through the committee?
It's gone through the committee, and he was approved by the committee, yeah.
You mentioned both of you mentioned something about Buffalo, Rochester. Though it's one district, does it make a difference? Do they really have so many from Rochester area, so many from the Buffalo? Or is that something
No,
that's just an agreement, or is that in fact?
No, there's statutorily designated seats. There's 4 active district judgeships, 2 of which are your duty station is in Rochester, and 2 of which your duty station is in Buffalo.
There we go. Didn't know. You implemented here, I cut to save this, opening statement for the American Bar Journal, and there you are, United States District Judge Elizabeth Wolford, a judge's push for diverse voices in court. Standing rules help women and young attorneys take the lead. Well, first of all, describe it, and what caused you to implement this?
The New York State Bar Association conducted a study examining the extent to which younger attorneys, and particularly younger female attorneys, were getting an opportunity to speak in court. And consistently throughout the state, they're not. And the report came out and suggested, among other things, that judges could play a role in trying to encourage younger attorneys. And frankly, my rule is not gender specific. My rule is geared towards trying to get younger attorneys an opportunity to speak in court. I'm a firm believer of the fact that if you want to be a litigator, if you want to be a trial attorney, you cannot wait until you're practicing 10 years to be examining a witness for the first time in court. You've got to have that experience when you're younger, when the expectations are not so high, and when you can screw up or make a mistake, and it's not going to be so outside what the realistic predictions are for you. And so I think it's very, very important for young attorneys to get opportunities to speak in court. And I think oftentimes, especially when you have paying clients, it's often difficult to convince those clients that a younger attorney should have that opportunity. So one of the New York State Bar Association's recommendations had been that judges can play a role by specifically encouraging those who appear in front of them to allow more junior attorneys to get a speaking role opportunity. And even if the more junior lawyer has that speaking opportunity, to not foreclose the more senior attorney to also kind of back clean up, so to speak, and be able to also get up and say whatever needs to be said for a particular court appearance. And so I adopted, and a number of judges, including Judge Vilardo, I know, have adopted similar or the same rules, which encourages more junior attorneys to have an opportunity to speak in court.
And in your booklets, by the way, are those local rules of civil procedure and local rules of criminal procedure, which are the judges shared with us as something that you can reference. As we are going to ask Terry and Rod to join us, and we're going to start talking about the best practices, what might you, as a kind of a, going from really the bar to bench, lessons sort of learned? I know you don't simply say, I want to be a judge and therefore these are things to do, because that's luck, that's a lot of serendipity, but a little bit of message to these lawyers here?
Well, I think with anything, I think you've got to work hard and you've got to produce quality work product so that no matter where you go in your career or whoever you're representing, you're going to be in the best position to promote those goals. I mean, I don't, as I said, I did not have on my goals in my career, so to speak, becoming a federal judge. But you need to have, if the opportunity presents itself to you, you need to be able to have the tools in place that allow you to be able to make that transition. I'm sure Judge Vilardo probably agrees with this. The role of being an Article III judge is enormous in terms of the subject matter that you are exposed to compared to what you dealt with when you were in private practice. I mean, I was primarily a civil litigator, but I'm exposed to civil cases in federal court now that I had no involvement with when I was in private practice. And you've got to be able to learn the law and learn how to be best prepared for any kind of court appearance. I mean, when I was in private practice, I never went into court unprepared, and I continue that practice as a judge because things are going to come up unexpectedly. That's court practice. That is part of being a trial attorney. And unless you have the preparation and the groundwork laid, you're not going to be able to deal with those unexpected moments as well as you might otherwise be able to.
And just to take off on what Judge Wolford just said, no matter how much you prepare as a judge, you're never going to know the case as well as the lawyers know the case. That's impossible. You just don't have enough time. There aren't enough hours in the day. So what that should tell you is that by preparing and by out-preparing your opponent, You can be, I talked earlier about being in control of the courtroom. You can be in control of the courtroom. You can know your case better than the judge, and you can know your case better than the opponent. And that puts you in control. And I think that's a really important thing to remember, that no matter, as Judge Wolford said, my practice was such a broad-based litigation practice, and there are things that happen now in federal court that I've never seen before, that I didn't know existed. And I try to learn it, and I think I have a decent handle on it, but I'm never going to have the handle that the lawyers should have on it by the time the oral argument comes around. So by preparing and understanding and learning, you can be in control of the courtroom. So, do you agree with that?
Absolutely, absolutely. I mean, you're absolutely right. You never want to have a situation where the judge knows the case better than the attorneys who are appearing in front of you either.
Thank you very much for that wonderful dissertation on kind of that ride, that life arc that runs from the bar to the bench.